Less than freehold estate section. A less than freehold estate is an estate held by one who rents or leases property. In a lease, the landlord is the lessor and the tenant is the lessee. Oral leases can be binding, but generally leases are written and give exclusive possession to the property to the lessee and a reversionary right to the lessor. A reversionary right means the owner has the right to regain possession of the property after the lease has expired. Just like in any other contract, a valid lease must contain mutual agreement, consideration, capable parties, and lawful object. The lessee has the right of quiet enjoyment and possession of property, which is the assurance that their possession will not be disturbed by anybody with superior title. The lease is a bilateral contract because both the landlord and tenant have obligations to perform. The lease agreement can restrict the tenant's use of the property and specify the conditions of which a security deposit may be retained for the duration of the rental. Death does not usually terminate the lease. Upon death of one of the parties, the responsibilities as stated in the agreement could pass on to the heirs of the deceased. Generally, when a property is sold, the new owner would have to honor the lease. However, this is not always the case. Hence, leases are personal property as they do not always run with the land. It is a contract with an individual person. Unless the lease forbids it, the tenant has the right to assign or sublet the property. An assignment is a transfer of contract rights, whereas a sublet is when you rent the property you lease to another person while still maintaining your responsibility to your landlord under your rental agreement. Constructive eviction is a term used in the law of real property to describe a circumstance in which a landlord either does something or fails to do something that he has a legal duty to provide. An example would be if the landlord refuses to provide heat or water to the apartment, as a tenant cannot live without water, thus they need to vacate the premise. This would be constructive eviction. Classification of a less than freehold estate includes an estate for years, periodic tenancy, estate at will, and estate at sufferance. An estate for years is a leasehold interest in land for a fixed period of time. It is often called a tenancy for years. An example of an estate for years would be a summer rental, as it has a defined beginning and end date. No notice to be terminated is needed as the end of lease is established at the conception of the rental. Periodic tenancy, which is also known as an estate from years to years, is a tenancy that is not bound to a lease with a fixed period like an estate for years does. A periodic tenancy follows a period such as a month to month, week to week, or year to year. Proper notice must be given to terminate this lease. Estate at will means that it can be ended at any time. An estate at will gives the lessee the right to possession until the estate is terminated by either party. The term of this estate is indefinite. An estate in sufferance arises when the tenant wrongfully holds over after the expiration of his term, often called a tenancy at sufferance. An example of an estate at sufferance would be a tenant that does not pay rent. In simple terms, the landlord is suffering. This is not a form of trespass, as at one point the tenant had the right to be on the property. The landlord would have to legally evict the tenant when a tenancy at sufferance is created.